What's up, everyone? Welcome to Let's Talk Markets with Dave Lauer. I am your co-host, Pink, and today we have a very special guest joining us, John Castiglione, who is the former Senior Enforcement Counsel in the Investor Protection Bureau with the New York State Attorney General. So thank you, John, so much for joining us today.
Thank you, Pink. So happy to be here. Really excited to catch up with you and to catch up with Dave. We've known each other for a long time now, although, honestly, we haven't seen each other in person, Dave. We both have a lot more gray hair than we used to. It's good to see you.
So much more. Kids and COVID for me. How about you?
It's pretty much how it happens, right?
Like Ferris Bueller said, life goes fast, huh?
Yeah,
it does. It does.
So let's start with something really hard hitting because, John, I heard that you grow your own heirloom tomatoes. And so I'm wondering when we get to have a little caprese salad marinara party. I'm totally all about those homegrown tomatoes.
You joke, Pink, but it is a struggle, man. Those things are fickle for sure.
They're like little babies every year. It's like my children,
You never know what you're going to get. And if you're sloppy, like my wife and I growing our tomatoes, you just grow them all sort of mixed in with each other and they start to crossbreed. And so you end up with these mutant tomatoes, which you hope you've discovered some great new strain or whatever. And most times they just don't quite live up to the hype.
Yeah.
But
that's the fun of it, right?
It is. It is.
Like a tobacco. You might come out with tobacco like Homer Simpson did. He accidentally crossbred with his tobacco.
I'll tell you, we used to grow tomatoes in Jersey, and then we move up here to Canada, and it didn't work. It just isn't working up here. I don't know what's going on. They it's totally different zone. They don't get as much light, and it's much harder.
They like it dry, they like it hot, right? And that's, not two words that I would necessarily use to describe Canada, although what do I know?
It's freaking cold here right now.
That's the stereotype anyway. We didn't have a great year this year for our tomatoes, although that could have just been a little bit of negligence on our part. Like, you got to really treat them nice and whisper softly to them.
Right. The last few years have been hard. We've had a lot of like pests, blister beetles is something I never even heard of until recently. And we've got, a couple acres, somewhat of a hobby farm. And the only thing we can keep alive is the goats. So
a couple acres, man. I've got like two little, 15 by 15 plots. So we really got to cram them in there.
Yeah. Well, I'm in the middle of nowhere. So it's a compromise.
New York is not for it's cheap real estate and open spaces, Pink.
Right. I'm in Oklahoma, so I'm actually in the Cherokee Nation. That's my Wilma Mankiller doll I'm really proud of back there. So lots of open space and plenty of room to roam.
All right, let's talk about smashing tomatoes and enforcement. So, John, you come with a pretty interesting background. I think you and I met when the Attorney General's office was investigating dark pools. You come into this with a good amount of market structure knowledge, a good amount of enforcement experience. You guys had some great cases that came through with some pretty significant fines. That kind of hits a theme that we tend to hear a lot from the retail investor community. But before we get deep into that, I think it's interesting. I didn't know about this, but you literally wrote the book on investor protection. You drafted, and you're the continuing editor of the Investor Protection Bureau Legal Standards, Practices Guide, and Enforcement Manual.
Was the editor. Once I left the state, I suppose somebody else took over that job.
So what is that? Let's just start there. And how does that work to protect everyday investors?
Sure. So, I arrived at the New York Attorney General's office in 2014. Prior to that, I'd worked for Latham & Watkins, a large law firm in New York, for about 7 years. And I came at an interesting time. It was a little more than a decade since Eliot Spitzer had very famously become Attorney General in New York and become the Sheriff of Wall Street. I don't know if he gave himself that name or somebody else did. But he was inarguably very successful. Yeah. Right. Very successful at expanding the use of New York State's Anti-Securities and Commodities Fraud Act, called the Martin Act, right? He was succeeded by Andrew Cuomo, who was Attorney General post-financial crisis. So obviously a very busy docket of big, complex cases against major Wall Street institutions. When I got to the office in 2014, Eric Schneiderman was the Attorney General, and he was by and large interested in continuing that run, if you will, of using the Martin Act aggressively. But because of that almost like idiosyncratic use of a very old law by Spitzer and then Cuomo, and then finally Schneiderman when I got there, there wasn't a lot of regularized practice. There wasn't a lot of history, frankly. There wasn't a lot of sort of process or procedure and thinking, in a broad sense about how to use this law that was written in the 1920s and amended over time in the 21st century. And so that's what I set out to do.
So that's okay. That's really interesting. Let's talk about that. So you came in, and when you came in 2014, that was a pretty pivotal year for market structure. That was when Flash Boys came out.
It was.
And what impact did that book have on the way your office thought about market structure and what was going on? And what did that lead to?
As I remember, and it's been a little while now, that book really, I think, fueled the fire of several of us in the Bureau, most notably myself, my old boss, my Bureau Chief, Chad Johnson, to really get serious about these complex issues of market structure. In the immediate months prior to Flash Boys, and I was not involved in this investigation, the New York Attorney General's office was looking at the early release of University of Michigan consumer sentiment data.
I remember that, yeah.
As you may recall, right? And it was like getting released, I don't know, 2 seconds early or something like that. And being traded on. Right. And so the office looked into that, and that was really like the storm clouds of what was really going on in the market, which was that certain players were using speed and informational advantages to trade on that other professional traders, but certainly retail traders didn't have. And so Flash Boys, say what you will about it, and again, it's been a long time since I've read the book, really showed a spotlight on how the market worked, right? And it wasn't the way that most people thought.
Yeah, Flash Boys, it was tough. It got a lot of things wrong, and that was a shame because they felt like unforced errors to me. It sort of wasn't necessary to tell the story he wanted to tell, but it got a lot of things right. And to me, it really honed in on something that we were focused on at IEX, which was that conflict of interest between routing brokers and brokers who were routing orders and operating dark pools, as well as the sort of conflict of interest on the exchange side where they were selling speed advantages. And that was something that your office really, laser focused on, I think, with some of the brokers, and that ended up resulting in a slew of dark pool enforcement actions that came out of your office rather than out of, let's say FINRA or the SEC. Why do you think that was?
Well, look, obviously I can't speak to what was or wasn't going on in offices that I wasn't working in. Right? What I can tell you is, what I was doing there and what my colleagues were doing. And it was very clear to us, being a little bit of an outsider, right? We were in a state agency that nonetheless had a very powerful law, right? Coming in with fresh eyes, perhaps, and seeing these conflicts of interest, as you say, that had really just metastasized in a way that was almost shocking for someone who, perhaps hadn't been stewing in that culture from either the government or the industry side for years, and maybe had not sort of accepted the way things were, right? And it took, it took me a while, frankly, to just understand the market structure. You and I had a lot of those conversations of just like, can you just teach me how some of this stuff works? Completely divorced from any individual investigation. Like, one of the most important things, I think, a government regulator or enforcement attorney has to do before diving into a new case or a new part of industry is just sit back and learn about it, right? And it took a long time to do that. And when we did that, it became obvious that, at least at certain institutions, like I said, those conflicts of interest had gotten completely out of control. And those were the matters that we focused on.
Yeah. All right, so let's talk about that. And it's interesting, you brought up how involved your office was. Not you weren't there yet, but how involved the AG's office was in the wake of the great financial crisis. And that's kind of the poster child, I think, for a lot of the concerns around and criticisms of enforcement, broadly speaking, that all too often enforcement is a fine and often a cost of doing business. And is that really a deterrent? Is that enough to deter bad actors? And why do you think we spend? Why do you think our enforcement agencies spend so much time? And generally they are civil agencies. We understand that, but why do they spend so much time on these civil actions and civil penalties versus criminal actions?
It's a good question. I think part of it is the different remits of different enforcement agencies, right? And so, for instance, let's start with the SEC. They're a civil enforcement agency, so that's what they do. They've got a lot of funding. They've got a lot of enforcement attorneys. They've got a lot of, call them sort of regulatory attorneys, right? And so that's just what they do. Same with the CFTC, same with the CFPB, for instance, right? The criminal matters are handled by sort of Maine Department of Justice sitting in Washington, D.C., in the U.S. attorney's offices that are all around the country, but frankly, most of which don't have the personnel or expertise to handle, for instance, complex trading cases of the type you and I have talked about for a long time. You'll have state attorneys general offices, around the country as well, all of which, or probably most of which, in one way or another, have criminal enforcement authority, but most of which very much do not have the kind of staffing or expertise one would need to hone in on call it Wall Street malfeasance.
So you think that it's not that enforcement agencies don't want to enforce things criminally or don't believe there's criminality. You think a lot of this is a staffing issue that, for example, the SEC comes across something, or you guys, in the Investor Protection Bureau came across something, and the ultimate result of that with the dark pool cases was fines, with the SEC often just fines. Sometimes the SEC works with DOJ, and there's some criminal enforcement, but it tends to be rare. Why shouldn't that cooperate? Why isn't that cooperation happening all the time and with most actions?
I think that's the question, Dave, is why is there not sort of tighter cooperation between criminal enforcement authorities and civil enforcement authorities when you see the types of behaviors that we see? And I think this gets to issues of resourcing in a way, which is to say, okay, so there's a matter that could maybe be matters that are flatly criminal tend to get appropriate attention by criminal enforcement agencies. FTX, for instance, right? He stole the money, right? And they charged him stealing the money. He went to jail. Okay, those things I think by and large get handled. What about those cases on the line? Well, is this criminal? Is there intent, right, to defraud? Was money in fact taken from investors, or was just sort of shifted around a little bit, right? When you have all those sorts of questions, civil enforcement agencies, and criminal as well, have a very difficult calculus to make about likelihood of success, about the time to prosecute that sort of case that it would take to gather evidence, interview witnesses, charge a crime, and then ultimately try it. One of the things that was, at least in my mind, most welcome to see about FTX was that it happened quickly, right? And I think it's fair to say that when justice is meted out quickly, that's a good thing. That is very much not how it usually happens, right? Yeah. These things can take a lot longer, and then there's really hard questions that need to be asked about whether that is the best overall enforcement strategy.
So do you think that there are changes we need systemically to kind of correct that? How can we, well, maybe let's jump back to the previous question. Do you think fines are a deterrent? Do you think like this acceptance, waiver, and consent approach accomplishes much of anything other than having shareholders pay the price?
I think it's a great question. And I think it depends on sort of what kind of defendants or respondents or actors you're talking about, Dave, right? Because, and I think this is where it makes sense to stratify this industry a little bit. There are giant institutional players, right, that in the course of conducting their business are going to see investigations. That's almost inevitable. I hesitate to use the word they to describe an institution that's made up of thousands of individual people, but maybe more importantly, that are made up of different silos of actors, right? Different trading desks, different compliance personnel, or whoever, right? I think by and large for those sorts of institutions, a fine would be appropriate, right? There is, even if some activity crossed into a violation, an enforcement agency should be looking at ways to go in, make sure they don't do it again, reform, and put a fine on it. Sure, I think that makes a lot of sense. There are much smaller institutions. There's thousands of brokers, thousands of investment advisors, fintech platforms of every stripe out there, where a fine, which even sort of looking at a press release, you or I might not think is significant, would be a very significant deterrent to their business, sure. Mm-hmm. And so, I think we should maybe think about those two different things in different ways. What I will say, though, is that there are certainly tools in the tool basket of an enforcement agency, whether you're talking about a federal enforcement agency like the SEC or FINRA or the CFTC or a state agency that we don't see deployed very often at all. And that would be a much harder look at whether certain individuals or entities should remain registered, right? You have to be registered to do business, in our line of work, right? And that is very much not a thing that you hear talked about very often when it comes to resolutions. And maybe it should be, to sort of bridge that gap that we were talking about between criminal prosecutions, which are really big deals, take a lot of time and are really just hard to do sometimes, and just another fine.
So what is it that you think, when we look back at the great financial crisis, I mean, usually we say nobody went to jail. I think that's maybe not 100% accurate. Maybe there was like a person or two, it gets thrown back. You're like, oh, it wasn't nobody. But I mean, it was effectively nobody, right? And these companies, they destroyed the global economy and, faced some fines. But why do you think back then there was it a top-down kind of attitude from Holder on too big to jail, or what was that already pervasive? Why do you think, you said when there's clear criminality, usually they go after it, but there was clear, I mean, at least from my perspective and a lot of people, clear fraud, clear criminality that caused the great financial crisis, the mortgage issues and all of that, like the robo signing and, clear malfeasance. What happened there? Why didn't people go to jail?
Look, I think it's a good, at this point, historical question. And I think there's a couple ways I might think about it. It seemed clear-ish at the time and seems very clear in hindsight that the incoming administration, the Obama administration, was not interested in wholesale criminal prosecutions of major bank executives, regardless of whether the evidence would or would not ever bear out a particular charge of fraud or some other violation of federal law. They were not interested in doing that.
Yeah.
Period. And again, thinking about it historically, that may or may not have been a defensible approach when it comes to the securitization of mortgage loans, right, writ large. Yeah. When it came to what I seem to remember as being very clear instances of fraud, signing people's names to loan documents, right, things like that. It seems to me, again, looking back on it, inexcusable that there was not a much harder look at the time about charging people with crimes. And when, you combine that with, by and large, the willingness of the administration to see millions of people evicted from their homes.
Yeah,
Right. It's to say it's a mixed record might be undermining. It was a really poor record.
Yeah.
And what I can tell you from the perspective of having worked at the New York Attorney General's office at the time, our office persisted in investigations of major banks for years after the financial crisis. And I did not work on those cases really at all. But what I recall is, and this maybe just is common sense, it's really hard to do those cases for a long time as a state regulator when you're not getting help, frankly, from the large agencies who are not in there year after year pushing. Contrast that with what we've seen in recent years on antitrust cases against the big tech firms. There you've got a coalition of state attorneys general offices working in concert with the Department of Justice and the Federal Trade Commission in bringing these cases. And it lends a weight and a momentum to those matters that would be impossible to sustain if it were just the states.
That's pretty interesting. Okay, that's a really good point. So you think if we look back on it, the lack of federal involvement and continuity was something that made it, so that states were on their own. States, for whatever reason, in the great financial crisis, don't seem to have banded together. Maybe they learned from that, and that has informed a new approach to antitrust today. Maybe going forward, we might see some of that same thing. Just maybe that dynamic will work on other types of cases as well.
Yeah, I mean, look, and you can think about it in terms of just think about what it would mean to prosecute either civilly or criminally a large fraud against a major company with virtually endless litigation resources.
Yeah.
That is not something that any individual state has a particularly good record doing. Just imagine, right? It's hard. It would take a lot of time. It may cross administrations, right? Attorneys general change over. And right. Yeah, they're elected officials. To have the resources of the federal government behind them and the enforcement authority, right? It's easy, or it was easy for me sitting in New York to send a subpoena to any financial institution operating in the United States because they're all either sitting in New York or have major operations here. Not so easy if you're an enterprising attorney sitting in an enforcement office in Arkansas, right? Or Minnesota, right? You think a lot harder about those issues, right?
All right, so then let's talk specifically about two enforcement agencies and two federal regulators. So I invited you on here because the CFTC came out with some guidelines for enforcement that, to me, on the surface, looked great. They said we're going to target recidivist offenders. We're not going to default to no admit, no denies. We're going to look for higher civil monetary penalties and potentially working more closely with criminal agencies. I got excited.
I snarked at you and said, Dave, don't get excited.
Yeah, maybe my bar is so low, but you're like, you make the very reasonable point. Why weren't they doing this all along? How disturbing is that? So what did you think when you saw that? Maybe that summer.
So yeah, look, I did some reflection on my brief Twitter bomb that I threw at you and realized I might change it just a little bit. It is definitely the case that everything that the CFTC said in its enforcement advisory is like bog standard principles for thinking about and executing on a civil settlement for an enforcement agency, right? In a certain sense, look, the CFTC says we're going to think about general and specific deterrence, especially for recidivists. Okay, yes, obviously, that's just a bedrock principle of trying to, craft a settlement. They say we're going to impose or think about imposing monitors and consultants more. Great. Okay, fine. what I realize a little bit more upon reflection is, okay, well, why would a government agency publish a piece of paper like this? Like, what is the point?
Mm-hmm.
Who is their audience, right? It isn't for themselves or their attorneys, because CFTC can go tell its enforcement attorneys to act in whatever way they want, and they'll execute on that strategy, hopefully. The CFTC could communicate that in any number of ways. So like, why did they do this? And thinking about how I used to do my job, right? What'll typically happen when you get to a place in an investigation where it seems like settlement is potentially an appropriate option, right? Sometimes the enforcement agency will approach the subject of the investigation and say, we think you should settle this case, and here's the structure that we want: dollars, remediation, monitors, whatever it is, admissions. Sometimes the subject of the investigation approaches the enforcement agency and says, hey, let's settle this thing. We know you don't want to go to trial. Here's what we think is appropriate. And then there's a negotiation. But somewhere in that negotiation, you start talking dollars and cents, and you start talking specific remediation points, whether it's a monitor, whether it's a change in practice, firing some people, whatever it is. And inevitably, when the government makes a proposal to the lawyers on the other side, the lawyers will say, that's not in line with your previous settlements. We've read them all, right? And for this bank, you did that. For this broker dealer, you did that. And so why are you treating us worse? So advisories like this, right? They're, I think, to give the government enforcement attorneys something to point to say, look, yes, we're treating you more harshly, perhaps, but the reason we should be able to do that is not necessarily because of these old cases, but our new line in the sand of this enforcement advisory. I think that's why.
Do you think, and maybe this is pure speculation, but do you think any of this is related to crypto and to this idea that the crypto industry wants to be regulated by the CFTC rather than the SEC?
I'll tell you what I think. I think well, put it this way. It would only be human nature for a lot of people sitting at that enforcement agency to feel a measure of embarrassment about what happened, right?
Yeah.
There were people there that got their pictures taken with people who are now in jail, right? There were many years of public statements about fostering innovation and responsible leadership, and there were, draft pieces of legislation passed around and endorsed by various folks, and it didn't work out so well for some of those folks, put it that way. And so, yeah, this could be part of that. Sure.
Okay, so let's use that as a good segue over to the SEC. First of all, you have some experience with this now. What do you think of the SEC's approach to crypto, and what Gary Gensler has said, and what he's done, or what his agency has done in terms of, essentially regulation through enforcement?
I think of it this way from where I used to sit, which is as an enforcer of the Martin Act. So the Martin Act was first written in the early 1920s. And so it predated the federal securities laws. It was before the Great Depression and the crash, right? And it wasn't really used all that much until like 1925, right? But then has now persisted for over 100 years. And in that time, there have been pieces added to it, some registration provisions. There's some provisions in there about filing your condominium apartment plan, like all sorts of stuff. The core of the Martin Act is as it was, right? Yeah, there's lots more. Broadway shows too.
I didn't even know what it was until I remember meeting with you guys like back in 2015, and I was like, how do you guys have jurisdiction over this? And,
right.
And the response was basically, we have jurisdiction over anything.
Oh, come on. I didn't say that. Really? I probably said that. But look, the act is almost 100 years old, right? And there has been a lot of financial innovation in the last 100 years for sure. But the core of the act always applies as it did, which is, by and large, if you are buying, selling, promoting, or brokering securities or commodities, in the case of the Martin Act, it covers both, you can't do fraud, right? You can't say untrue things, essentially. You can't mislead people, right? And that is the basis of the act. That is also the essential basis of the federal securities laws. Right. And so I think it was never the case that the federal securities laws were inadequate to enforcing fraud in this market of things that are bought and sold just like securities, that are traded on things that they call exchanges, so forth. Now, it's a little different in the case of cryptocurrencies, because at least two of which, the biggest two by trading volume and market cap, if you want to call it that, Bitcoin and ETH, have always been considered commodities, right? And it is not typically the case in the markets that commodities intertrade with securities like they do on a lot of cryptocurrency trading platforms, right? So there's some differences there. But to me, anyway, it always made fundamental sense that between the federal commodities and securities laws, that the federal government had, by and large, the authority it needed to, at the very least, investigate potential fraud. Then when it comes to, the status of a security of any given cryptocurrency, then you just have to look at the facts and make a determination.
So I think when I look at, it's funny, I get two completely different perspectives on this issue, depending on who I'm talking to. Talk to a lot of people who are very crypto friendly, and they say there's no way it's a security. The SEC shouldn't be involved here in any way. And I talk to a lot of people who believe very much that these are securities by and large, and that we have frameworks that work even if they're imperfect. And I look at it and I just see a lot of people having been defrauded, and for years and years, and so many people who have lost so much money. And so I have little sympathy for people who say the SEC shouldn't be involved, because I don't hear the alternative. Like, okay, if not them, then who is supposed to be protecting people today, like this minute? Who should be investigating fraud and trying to prevent it, and if not prevent it, trying to get some restitution for people who are losing money? At the same time, I hear the argument that this doesn't perfectly fit in, the definition of an investment contract. And maybe the courts are going to, so far the SEC's had a pretty good track record in court, but who knows with these courts and this Supreme Court. What do you think? Like, who should be who's the cop on the beat here? Like, who should be on the beat, and why have they failed so miserably up until this point at protecting people?
I guess I would take a little issue with the premise, Dave, which is to say there can be more than one cop on the beat, right? Yeah. We have, in the United States, you can trade a lot of different things, right? Yeah. You can trade things that we all know are securities, Amazon common stock, right? You can trade commodities, pork bellies or gold bars, right? That's a different cop on the beat. These days, you can essentially trade digital ads, right? The way ads are served on the internet is through an underlying system of brokers and a central exchange that conducts auctions, right? There's a different cop on that beat, although that's still kind of being stitched together. So there could be different cops on the beat, right? What I think has probably not been optimal is the scenario that seemed to have played itself out over many years, going back to maybe 2016 when we all started learning about cryptocurrencies in the first place, of like who was going to do what and how. And I remember in my time at the New York Attorney General's office saying to one of my colleagues, and I think this was about 2018 timeframe, well, essentially, they'll sort it out soon and we'll know who's going to do what, right? Yeah. Right. And many years later, it still hasn't really been sorted out. Now you can, speculate about why that is. There was a very significant change in administration, right? There was the inability of Congress to pass a law saying who should do what, as is Congress's right to do. So there's explanations for that. I think it is I think it's consistent, Dave. Maybe you'll tell me it's not. I think it is consistent to say that the federal enforcers collectively had all the authority they needed to regulate and enforce in cryptocurrency markets, while at the same time being a little underwhelmed in how those agencies executed on that authority by failing to really come to terms with each other about how it was all going to work.
No, I think that's fair. I think you can look back, for example, at like Jay Clayton's SEC and see an SEC that was very friendly to large institutions and companies that didn't want to crack down on crypto for whatever reason. The same thing with the CFTC at the time. And then, there was kind of a sea change when Gensler came into the SEC and the Biden administration on all sorts of different areas, and enforcement of securities laws is definitely one of them. I mean, the SEC touts, their record fines now year after year, and they've had some pretty big cases. At the same time, it often feels like it's not getting to root cause issues.
Yeah, Dave, I think that's right. And I wanted to pick up on something that I think you were maybe implying before, which is when lots of people start losing money and lots of fraud starts bubbling to the surface, what do you expect to happen?
Yeah.
Right?
Yeah.
Federal agencies are going to get involved, right, and they are going to be aggressive in how they apply their own authority. And, maybe we could have like a philosophical argument about, or a lawyer's argument about whether that, is down to the last period and comma in their enabling laws. But that's just the way it works. That's human nature. That's going to happen. And so, as they say, when the tide goes out, you get to see who's naked, right? Is that what they say? When fraud starts coming to the surface and real investors start losing money, the agencies are going to step in. And I think that's appropriate.
All right, we're running low on time. I did want to ask you one last question, because we've sort of touched on antitrust. It's something that you and I think care a lot about, that we see as a root cause issue sort of across the economy. When Biden came in, he put out this executive order on competition, and I think the SEC took that and they started to look for ways that they could, try to address some of the inefficiencies and the concentration issues in markets, using that as some of their authority. And one of those ways was the order competition rule that they proposed. So I'm just kind of curious, what your thoughts are on the order competition rule. I don't know if you've actually looked deeply into it, or what you think of it from an antitrust perspective.
I have not looked super deeply into it, Dave. What I can tell you is I think you are right that when the new administration came in, it came in with an agenda in place to address competition issues writ large. And for market structure nerds like you and me, that has expressed itself in different ways. It has expressed itself in the market structure rules that the SEC has proposed. It expressed itself in the by and large, the antitrust matters against the big tech companies, specifically Google, and its dominance over the search ads and display ads marketplace.
And now Amazon.
Yeah, and now Amazon, right? Which, one of the real maybe eureka moments that I had, and I was probably among the last to get here, because in retrospect, it seems very obvious, is that whenever you have an electronic real-time marketplace, and real-time put it in quotes because we all know, we understand. When you ever have a real-time electronic marketplace, it seems to be the case that conflicts of interest creep up in all the same ways, right? Yeah. In the digital ads world, we see Google that essentially acts as a broker on either side of the market and owns the exchange in the middle. Yeah. And there's currently there's a couple of very large federal litigations about whether Google abused that dominance by doing all of the things, Dave, that you and I were talking about in 2014, giving preference to certain traders or ad buyers, giving preference to itself, speed impediments, informational advantages. It keeps happening again and again. You saw this all in crypto. Using FTX as a good example, that was like so far of a conflict of interest, it fell into pretty open and obvious criminal activity. But what was he ultimately doing? Giving his own traders an informational and speed and margin advantage, right?
Yep.
Right. And these things come up again and again. And it's almost like you can have a sort of general law of electronic markets that these conflicts of interest, if they are not controlled, will run out of control, right? Someone I think both of us know, Dina Srinivasan, who's an independent academic out in San Francisco, has done a lot of good work on this. It's a schema that you can really apply to equities, commodities, cryptocurrencies, digital ads. There'll be something else that we haven't thought about yet that you could probably apply to soon. You see it again and again.
Yeah, and so I think what you will about anything with the current administration. I think from an antitrust perspective, it has been an exciting time. There have been massive changes made. I think it's the kind of thing you don't see the effects of necessarily right away. With some things you do, but with some of it, it really is going to unfold over years. And I think that's how Gensler sees a lot of the market today, is like these pockets of concentration, and he's trying to get at them, and he's trying to break that up and actually just make it an open and competitive system. That's why.
Yeah, I hope so. Yeah, and I look, like you said, reasonable minds can differ on any given case or proposed rule that's come out of the SEC or anywhere else. That seems to be their intention, and I think it's a good one.
Yeah. All right. Well, this was great. Thanks, John. Really appreciate you coming on. Fascinating conversation. And I'm sure there will be reasons in the future to come back to it and maybe talk some current events as different people have to face the music on what they're doing today.
Well, thank you so much for having me. It was great to see you again, and I look forward to it.
Awesome. Thanks, John. Thanks, everyone, for listening. Pink, do we know what we're doing next week? I don't even think we have that set yet. Right?
We're almost up for Macro Market Monthly again, so we'll touch base either with our friend Dennis Dick from Pre-Market Prep over Benzinga's Pre-Market Prep, or Claudia and Ophir should be coming up the next week or two. So we've got a lot of macro discussion to have. It was nice to get even more macro on the regulation side today and get a better idea and understanding of all of the obfuscation that's happening on the technique side of the almost too big to fail entities, it sounds like, versus people like John that are just trying to make everything fair and just. So thank you for what you've done to represent retail investors as well, John.
I'll also mention that we've got our first sort of town hall coming up, our Irvin's first annual update. So I hope everyone listening can join us December 15th at noon. You should have an email if you're on one of our mailing lists. And if not, go put yourself on one of our mailing lists. Go to irvin.finance, put your email in there, and we'll make sure to get you the details. That's December 15th at noon Eastern time. And we've had quite a year here at Irvin with the launch of our beta product, over 21,000 of you using it. And lots of exciting stuff on the regulatory advocacy side. So we'll be excited to talk about all of that, take all your questions, and tune in next week. Of course, like and subscribe, give us a good rating if you like the episode, and we appreciate all of you for listening. Thanks.
Till next time.